My name's Darren Senga from VLF's Dallas office. I'm joined here today by Joe Lanza and Dylan Fetterman from VLF San Antonio office. Welcome to another installment in Beth and Law Firm's video educational series. You also have the possibility of retainage.
Yes.
And just as a general proposition, retainage is the concept that the party who's obligated to pay, so effectively that's going to be the owner here, should hold back a certain amount of money so that there's an assurance that the subcontractors and the laborers and the material men on the project get paid by the general contractor.
That's right.
So is there any statutory guidance telling us how much a commercial project owner should be retaining?
Yes, it's generally 10% of the contract price or 10% of the value of the work that was completed.
And Joe, they're supposed to hang on to that for 30 days following substantial completion, right?
That's right.
That's right. So Dylan, we know that it's substantial completion. That
Dylan,
30-day timeline.
we talked about substantial completion triggering the final payout of that retained amount.
Is there any guidance
on
exactly
what substantial completion actually comprises?
Yes, it usually means completion of all the work, including extras and any change orders, but it doesn't usually include warranties or repairs.
Gotcha. So that gives you an example of how a project owner, having been delivered a project, is supposed to hold money in the account, 10% of the project, until that they have assurances that the subcontractors have been paid. Again, as a practical matter, they'll generally condition release of those things on a release of liens from the subcontractor, so that there's not going to be a double pay problem. So Dylan, on retainage, we know that the project owner is supposed to hold the money for 30 days before paying it out to the general contractor. Is there a simple way, is there a timeline, or is there a method by which the subcontractor or lower tier contractor needs to make a claim on that retainage? How does that work?
Yes, they would have to send a notice to the owner, and the deadline's it's 30 days.
So effectively, within that same 30-day window, that the project owner is not paying the general contractor, the same 30 days, right?
That's correct.
So Dylan, one of the things that these notices do is, from the various tiers of contractors or subcontractors, is they put the owner on notice when the general's not paying his subcontractors.
That's correct.
And it looks like the intent of the legislature here is to protect the lower tier subcontractors from not getting the value that they've provided on the improvements to the project. And they want to, so long as you do your notices timely, you want to make the property owner face liability if they've not acted on the basis of that notice.
That is part of the intent.
So when a subcontractor sends a notice of non-payment from the general contractor and an intent to file a lien to the property owner, but then that property owner fails to withhold the contested amount from the general contractor, that property owner can face personal liability as well as the risk of a lien, right?
Yes, and that's why it would make sense for a potential claimant to send notice as soon as they realize that there's an issue with payment.
Great, so that puts the owner on notice that the general contractor is not paying his subs, and the owner better start withholding some money so that the subs have a way to get paid.
Absolutely.
So that's the basics of perfecting a lien, pursuing retainage claims, and using the fund trapping letter to make sure that a subcontractor gets paid well. Joe, are there any other basic protections for a contractor or a subcontractor?
There is the Prompt Pay Act, which requires landowners and contractors to pay contractors and subcontractors promptly. If you don't make your payments on time, the penalty there is 1.5% interest a month, which is roughly 18% per annum, and it's higher than what we have as a prejudgment interest rate, which is only 5%. So that's a substantial uptick in what you could be liable for if you're making late payments to your contractors, subcontractors.
So more than triple the interest provision. Great, with that, I think we've covered some common sense ways for our Texas-based contractors and subcontractor clients to protect themselves and ensure payment on projects. If you've got any further questions, please reach out to bethandlaw.com. We've got plenty more information on this topic, or reach out and discuss it with one of our lawyers.